Good morning, everyone. My name is Leslie Dock, and I am the chair of Protect Our Care. Thanks for joining us today. We are here to talk about the Kelley v. Becerra lawsuit, a lawsuit currently in front of a Fifth Circuit Federal District Court judge that, if successful, would end guaranteed free preventive care that more than 150 million Americans rely on every year. I'm joined today by Andy Pincus, a partner at the law firm of Mayer Brown, who has argued more than 30 cases before the Supreme Court as an adjunct professor of law at Yale Law School, and has personally been integrally involved in all of the major lawsuits seeking to undermine the ACA and many other key healthcare provisions for many years. We're joined by Kaye Bender. Kaye is the executive director of the Mississippi Public Health Association, also served as dean of the University of Mississippi Medical School of Nursing. And by Donna Marie Woodson from Charlotte, North Carolina, a cancer survivor, who, as you will hear in her own words, if not for the preventive services of the ACA, would not have been diagnosed with colon cancer and breast cancer in 2015, and then received the preventative care, the health care that she needed for her own survival. Before I turn the call over to Andy, let me just make a few introductory remarks. Many of us on this call are far too familiar with ideologically and politically inspired lawsuits whose goal it is to take away healthcare from tens of millions of Americans. Kelley v. Becerra is another one of those, but this time would affect more than 150 million Americans, because this lawsuit goes to the heart of healthcare that people are guaranteed to be free, even if they're no matter where their insurance is from. So this applies to employer insurance as well as to ACA insurance. The Affordable Care Act guaranteed access to over 100 preventive healthcare services completely free of charge. And this life-saving care has become a bedrock of our healthcare system. It improves health outcomes, reduces disparities, and reduces costs. And as I mentioned, in 2020 alone, more than 150 million Americans use these services. The Kelley versus Becerra lawsuit has been initiated and driven by long-term foes of the Affordable Care Act, marriage equality, contraception, and diversity policies, and is being argued before the same federal district judge whose decision invalidating the entire ACA was reversed by the Supreme Court in 2020. Here are just some of the preventive services at risk. Free guaranteed vaccinations, including childhood vaccinations and COVID vaccinations. Free guaranteed prenatal screenings and treatments, including screenings for such things as preeclampsia. Free guaranteed cancer and health screenings. Free guaranteed routine infant and child care. Free guaranteed pre-exposure prophylaxis to reduce and prevent HIV transmission. And free guaranteed contraception. With that sobering background, let me now turn this over to Andy Pincus.
Thanks, Leslie. As you say, it's really an amazingly broad category of preventive services that Americans take for granted that are at issue in this case. And the statute just divides them into four categories. And I think it's important to explain that because these services are designated by experts, public health and medical experts, based on the evidence. So the first category are services with a rating of A or B, recommended by the U.S. Preventative Services Task Force, which is a group of nationally recognized experts in prevention and evidence-based medicine. The second category, immunizations recommended by the Advisory Committee on Immunization Practices of the Centers for Disease Control and Prevention. We've heard a lot about them in connection with COVID. The third category, preventative care and screenings for infants, children, and adolescents that are in guidelines put out after expert consultation by HHS's Health Resources and Services Administration. And then finally, preventive services and screenings for women's health specified in those same HRSA processes. So all of these four categories, the 100 things that have been designated under them, are subject to challenge across the board in this case. And let me talk about the grounds for that legal challenge. There are two basic arguments. One is a supposed constitutional flaw in who decides, that is proponents say rests on the Constitution. They argue that the decisions with respect to these services have to be made by somebody who's nominated by the president, confirmed by the Senate, and because the statute doesn't expressly say that, it's invalid. And then they say there's a separate constitutional flaw in the standard for deciding what services are covered and which aren't, that Congress didn't specify sufficiently specific standards, and therefore the provision violates what's come to be known as the non-delegation doctrine. It delegates legislative power to an executive agency, and that's unconstitutional. Those two arguments would invalidate the provision across the board. There's a third plaintiff-specific argument that's in this case, as Leslie mentioned, about paying for PrEP treatments that prevent the spread of HIV. These particular plaintiffs claim that that violates their religious beliefs. That claim of invalidity would only apply to those plaintiffs and would have to be litigated on an employer-by-employer basis, so I'm not going to spend much time talking about that. I want to focus on what the government is responding to these across-the-board challenges. First of all, the government has a broad argument and a powerful argument that the plaintiffs here don't have standing. They don't have the legal right to get into court because they haven't asserted that these provisions injured them. If you remember back to the California against Texas case that Leslie mentioned, the last Supreme Court case on the ACA, 7 justices agreed with that argument in that case, that the states who were challenging the ACA across the board hadn't shown the legal standing, is the technical word, to get into court. So we'll see what success that argument has here. Let me start with the who decides claim. The government has responded with a number of powerful arguments. First of all, Secretary Becerra has issued a document ratifying all of the designated services. And as the government explained, the statutes that govern HHS give him authority over all HHS components, and therefore that ratification is a powerful argument that, to the extent there is an argument that someone appointed by the president, confirmed by the Senate, has to decide, that's happened here. Then the government says all of these entities, other than the Preventative Services Task Force, the first group I mentioned, the immunization group and HRSA, the Women's and Children's Services, have to be accepted by government officials who are subject to control by the secretary. So again, with respect to those, if the argument here is that someone who is subject to control by a Senate confirmed person has to make the decisions, that's dealt with the way those decisions are put into law today. Finally, the Preventative Services Task Force, if it doesn't fall within that category, then it's an independent body whose standards have been incorporated into law. And that's the case with many statutes that take private sector established standards and apply them to government operations. And so that's exactly what's happened here. Many, many statutes do it. So that argument also is a powerful one, rejecting the who decides claim. So 3 separate arguments by the government as to why that claim shouldn't succeed. With respect to whether there are sufficient statutory standards for deciding what goes into these preventive services categories and what doesn't, the courts have said Congress can use broad delegations. In a number of contexts, they've said just saying, do what's in the public interest is enough. Here, the statutes emphasize evidence-based decision-making. That should be more than sufficient. But there's even more detail here because Congress, as I said, designated specific entities that were already in operation and already designating preventive services when it enacted the ACA. And so when it picked those entities, it necessarily endorsed the standards that they were applying. And that certainly is more than sufficient to satisfy this standard of sufficient specificity in the statute. So pretty strong arguments by the government. We will see what happens. Let me just talk for a minute about what's going to happen next in the case. As I think people know, tomorrow there's a hearing. The legal arguments in writing have been filed before Judge O'Connor. He has convened a hearing so that he can question the lawyers and they can make their legal arguments. And then after that, at any time, he may decide this case one way or the other. We don't know when. But obviously, that's going to be an important moment, and a critical question is going to be if Judge O'Connor, as he has in a number of past cases, rules against the ACA, does he put that decision on hold pending appeal? The next step would go to the Court of Appeals for the Fifth Circuit and then ultimately to the Supreme Court, or does he make that decision immediately effective? If it's put on hold, there's no change in people's real world lives until the case is finally concluded. But if he makes it immediately effective and neither the Fifth Circuit nor the Supreme Court put it on hold, then there could be draconian immediate effects as people's health plans turn over at the end of the year or whatever their time is. There no longer would be the guaranteed free coverage mandated, as Leslie explained, and Americans could begin to lose that coverage very quickly. So I'll stop there.
Yeah, it's sobering. And just to close, we're at something to what Andy said, and this would leave people at the mercy of the insurance companies and their employers. And we're talking about everyone who kind of feels comfortable today about their employer benefits. They're guaranteed by this provision. And there's very, very little time left between whenever this decision comes with the advent of the new plan year. So at best, we get incredible chaos. And at worst, we get a lot of people dropped. And there's likely to be both. Let me now turn it over to Kaye, who can speak not only from her academic background, but just as importantly from her feet on the ground in the state of Mississippi. Thank you.
So thank you for letting me be here. Yes, my comments are coming from my nursing background, actually, and spending many years in public health. The idea of having preventive services is so basic to me as a nurse, and I've seen it over and over, that it hardly seems logical that we would in 2022 still be pondering why preventive services are important. We spend a huge amount, as you all know, of our gross domestic product on health care services, and yet we still rank 28 among 36 countries in terms of life expectancy. So when I went into nursing, I was taught that we look for the causes of illness and the causes of death and do everything we can to intervene before they become catastrophic to the family and to the healthcare system. These services that Andy just described, immunizations, prenatal screening, screening for cancer, just basic routine infant and child health care services, preventive medications for individuals with HIV, and access to women's health services, including contraception, are basic. And compared to the consequences of not identifying healthcare issues early and intervening before they become catastrophic are just amazing. Today, 7 in 10 deaths in the United States are related to chronic diseases such as obesity, diabetes, high blood pressure, heart disease, and cancer, all of which are largely preventable. And in my home state of Mississippi, all of those rates are way off the charts. But what we have seen is with the Affordable Care Act and other kinds of insurances that are available to people independent of employment, but who put the focus and the emphasis on prevention, we've seen early intervention so that we avoid amputations due to uncontrolled diabetes. And we get at that high blood pressure early enough to avoid stroke and heart disease. 90% of our healthcare dollars are spent treating such diseases, and only 3 cents of each healthcare dollar is spent on prevention. It's just backwards. We have made tremendous progress with the ACA and with other health insurances who put prevention where it needs to be, but it is archaic, in my opinion, as a nurse and as a public health professional for us to link our health and our prevention of catastrophic health problems to employment or to the whims of insurance companies. Prevention should be at the choice of the patient and of the individual. And so for that reason, we need to do everything we can to protect those preventive benefits.
Thank you, Kaye. And just again, a reminder, Kaye is the executive director of the Mississippi Public Health Association and was dean of the nursing school for many years, in addition to her treatment of patients herself. So thank you. Let me now turn it over to Donna Marie Woodson, who can tell us both her own story, but also what she sees in her own community.
Hi, good morning. Thank you so much for inviting me to speak today. My name is Donna Marie Woodson. I'm a 7-year survivor of cancer. And the free screenings that are included with the Affordable Care Act literally saved my life. When my husband and I moved to Charlotte, we were uninsured for a while. So I put off my screenings, my mammogram, my colonoscopy, which I always was regularly keeping up with. But because of the cost, I said, I'm going to roll the dice and I'll probably be okay. I wasn't worried about it. So when the Affordable Care Act passed, I went ahead and made my appointments. And the first I made was for my colonoscopy, and went in. And before we even left the building, my doctor came in right after and said that he was 99.9% sure that I had cancer. And if I wasn't already laying down, I would have been on the floor because, like I said, I've been healthy my whole life. Nothing had been going on with me. I didn't have any sort of chronic illness or anything. So I was shocked and floored, and it just hit me that you never know. You never know walking around if you don't do screenings. If there aren't preventative services, this could happen to other people as well. And it's frightening because going through that process, going and prepping for surgery for my colon surgery, had to have partially removed the CT scan and all of the prepping. They said they thought they saw something in my breast area, and so they said, but no, we needed to get the surgery done first, so we'll hold off on that for the moment, but after you are recovered from the surgery, we want to go back and have you have a biopsy. And sure enough, it was breast cancer, and the two were not related. That was the craziest thing to me. It wasn't one caused the other, or it was just bizarre. And even my doctor said that very unusual case. So the screenings, preventative care is everything. Because I think about it on a daily basis. How many people are walking around not getting screened because they don't have health insurance? And it's expensive. It's not cheap to get the screenings. We're saving lives. And it's also saving all of the trauma and the stress that a person would have to go through emotionally and monetarily to pay for all of the services, the hospital, the surgeons, and even aftercare. I still needed to have that. I needed to go, and I still go back to my doctors and get checked in. And that all costs money, and it doesn't make any sense to me why anybody would want to take that away. I just cannot fathom that in my mind. I don't know whether they don't think it's important, they've never experienced it, but I'm here to tell you that these screenings are essential to life. And in my opinion, those who want to take those free screenings away for cancer, for children, for all kinds of different issues that we can, tamp down and take care of without it turning into this big traumatic experience in people's lives. I really it floors me. I think that these people who want this to happen really disregard and have a disrespect for human life. Otherwise, it doesn't make any sense. Why would you go through all of this to take rights away from people? I don't understand that, because it's not a game, it's madness, and we're playing with people's lives. And it has to stop. It has to stop. I work as an advocate. I talk to people all the time. I was in getting my mammogram, and there was a woman, she was in her 40s, and she had never had a mammogram. She said, I don't have that in my family, so, I never really thought about it. And I said, no, neither did I. People don't know. You don't know what you don't know. So having access is life-saving, and I fight for that every single day, educating people and trying to make just this country healthier. Preventative services are everything. Like I said, literally, the Affordable Care Act and the free screenings saved my life. Everybody deserves that. Everybody deserves quality of life. And that's what these screenings represent. And taking those away, I say, will kill millions of Americans here. And I don't understand. It makes me very, very sad and angry at the same time, multitude of feelings. But thank you for letting me share my story and just how heartbreaking it is when I found out about this. It really is very disturbing. And hopefully we will be able to rise above this and make sure that these rights, because healthcare is a right, are not taken away from the American people. Um, Again, thank you so very much. And we must stop this madness. This is not a game. Thank you.
Thank you, Donna, for sharing your story and, letting people understand what's happened around your kitchen table, but what's going to happen around tens of millions of kitchen tables around America when people wake up one day and understand these things are now denied to them, they can't afford them, or they may never even know, in a sense, what they're missing. So thank you. Let me turn it over to my colleague Trey and take some questions from the reporters on the line. Trey?
Okay, so thanks, Leslie. If you're a reporter on the line, you can let us know you have a question by clicking the raise hand button at the bottom of your screen. You can also use the chat button or email us your questions, and I'm going to give it a few seconds for people to raise their hands.
Leslie, while we're waiting for those, one other thing that I was thinking about when Donna was talking is we want people to be healthy enough to also be able to work or go to school. And those kinds of things that we all treasure and value in this country. And I've seen, as Donna pointed out, people who are between jobs, especially after COVID, when we've had all the job shifts, right, who have been covered for screenings and who found minor things, but they were able to get those corrected so that they were then ready to go back to school or go back into the workforce healthier than they would have been if they had not had those screenings provided to them. So that's another sort of thing I don't totally understand, because we do want people to be healthy enough to learn and work. And these screenings are an important part of that.
Yeah, for sure. And vaccinations, which keep people in school and keep people at work. Trey, do you want to go to the first question?
Yes. The first question is from Alice from Politico. You should be able to ask your question now.
Thank you so much. I wanted to ask if the folks on this call think that the recent Supreme Court ruling on the EPA, which has sort of sweeping implications for policymaking and challenges to the government's right to make policy, if that is expected to come into play at all.
Maybe I can start. I think you're talking about the West Virginia case and the major question doctrine, although that's been invoked in a bunch of places. I don't believe it's been invoked in this case, and I think the challengers would have a hard time relying on it because this is a pretty straightforward statute that specifically addresses coverage of these preventative services. So there's not, it's not as if this is some general authority that HHS is using to require the coverage of preventative services. The provision was explicitly designed and explicitly says these services have to be covered. They have to be covered without cost sharing. And here's the process for deciding what services are in or out. So I think that specificity means that there's really no occasion to bring the arguments that were at the bottom of that EPA case into this one.
Alice, any follow-ups or does that help?
Very helpful, thank you.
Trey, the next one.
Okay, the next question is from Tierney from CNN. You should be able to ask a question now.
Hi, can you hear me?
Yes.
Hi, I also wanted to ask about a recent Supreme Court decision. I'm wondering if there's any implications from the Dobbs case we should be thinking about with the circumstances around this case, whether there's any sort of implication with what Justice Clarence Thomas wrote in his concurrence about other rights, privacy rights, and whether they could weigh on the PrEP claims or any of the other sort of moral, religious claims that the plaintiffs are making, or if there are any implications we should be thinking about in terms of the importance of these services in this new abortion landscape where there are already other sort of things complicating women's access to care, how this case adds on to that.
Andy, do you want to take the legal parts?
Yeah, I was going to say I can talk about the legal piece and maybe someone else can address the access to care piece. I don't think so. The claims that I mentioned focused on the PrEP treatment that prevents the spread of HIV are based on the Religious Freedom Restoration Act. So it's a statutory claim that the requirement that those services be covered interferes with the religious rights of the plaintiffs. So they have to show two things. They have to show that there's a burden on their religious beliefs, and the government in its papers has a pretty strong argument that they just haven't met that test, given that they haven't shown a link between covering these things and something that interferes with their beliefs. And also the government points out that not even if such a link can be shown, the statute allows a government regulation to stay in place if it serves a compelling interest. And here preventing the spread of this very harmful disease is surely a compelling government interest.
And from the access standpoint, the ACA, of course, guarantees women access to at least one type of birth control from all of the FDA-approved methods. And today, about 63 million women have taken advantage of that, which saved about $1.4 billion to them on their birth control. Before that, women were having to either pay for all of it or 30 to 44% of it. No-cost contraception is a key way to prevent unintended pregnancies, which goes back to what I said earlier about that also allows women the opportunity to plan their lives, allows families to be able to plan their lives so that they can finish school or go back to school or be able to work and support their families. And it also reduces abortion rates because you don't have unintended pregnancies or unplanned pregnancies that are more complicated. Spacing out births also, science shows us, has caused us to have healthier babies. when they are born. So there are all kinds of reasons for women to be able to have access to this contraception. That women who are religious, of all kinds of religious persuasions, have access to, should be available to all women.
Thank you, Kay. And Kay's described, I think Annie described the legal issues and Kay's described the real world issues. And of course, the Dobbs decision does exacerbate the danger of this lawsuit for women, as Kay said, for families, and of course for children who would no longer be guaranteed basic childhood vaccinations, and whose pregnant mothers would no longer be able to receive core prenatal care, core screening, to be sure that their babies are born healthy and can grow healthy. So this, the Dobbs decision in those states that have gone ahead and ended the federal right to abortion, the need for these preventive services and contraception is even greater and more stark. I think that my colleagues say that was the last question. Also, we're trying to keep on time. So I want to thank everyone who's attended, thank our panelists. We will be sending out both some fact sheets as well as a transcript and audio and video of this. We'll include, if Andy's willing, his direct email so that he can answer additional questions that people have. But of course, you could always reach us at Protect Our Care as well. We're happy to connect people with Kay and Donna Marie at any point. Thanks to everyone. And please, those on the line, pay attention to this lawsuit. It's very important that this not happen in the darkness. Thank you.